This lecture is about the law of homicide. I will use 3 examples in this lecture as I go through the law, and let me tell you about these examples. Example 1 is the case of a mentally ill grocery store clerk. Now this clerk had been in and out of mental institutions for all of his life and was working at the grocery store and got into an argument with a customer who said that the clerk was blocking the aisle. The clerk, in a rage, pushed the person, says, "I'll kill you," and pushed him. The person fell, hit his head, and died. The people, Don is the grocery store clerk, and Vic is the person who died. Our second example that we will use involves a convenience store robbery. In this case, Don and Art went to Vic's convenience store, Vince's convenience store, actually, not Vic, but Vince, V-I-N-C-E. Don and Art robbed the convenience store, and as they ran out to the car to get away, Vince followed them with a gun and several times shouted, "Stop or I'll shoot." They didn't stop. Vince shot and killed Art. Don shot back and killed Vince. In our third example, Don came home one day and found Vic assaulting his wife. He pursued Vic. Vic got away. He has been looking for Vic for 3 months. Finally found Vic. When he found him, he found out where he was, actually. He took a gun with him to where Vic was, and Don and Vic got into a heated argument. Don then shot Vic in the head. Vic was taken to a hospital. The doctors at the hospital said that Vic was brain dead, but they put him on life support systems, and 2 days later, they pulled the plug. Don and Vic, of course, died, if he wasn't already dead. One of Don's defenses is that Don did not kill Vic, that the hospital doctors killed Vic because they pulled the plug, and his body was still alive until they pulled the plug. So those are 3 examples: the mentally ill grocery store clerk, the convenience store robbery, and Vic, who assaulted Don's wife and was later killed by Don. Now, with those examples available to us, let's talk about the law of homicide. First of all, the word homicide technically does not have a criminal connotation. It's simply one person killing another, and the name of that is homicide. We often see homicide now used to mean the unlawful killing of one person by another. And you see, so the word is kind of changing use, and you have to kind of keep that in mind, that you see people using it both ways. Homicide meaning the killing of one person by another, and homicide meaning the unlawful killing of one person by another. I will use it here to mean simply the killing of one person by another. Now we begin our analysis of the law of homicide with common law murder. Common law murder is defined as homicide. Is defined as, I'm going to do this differently. Instead of starting with common law murder, I'm going to start with first degree murder. First degree murder is common law murder plus aggravating circumstances. So we obviously have the problem of deciding what is common law murder and what aggravating circumstances will elevate common law murder to first-degree murder. So we next move to common law murder here. Common law murder is homicide with malice without excuse, justification, or mitigation. This makes sense in the sense that the homicide here is the actus reus of the crime. The malice is the mens rea. And these are defenses: excuse, justification, and mitigation. Excuse is a complete defense. We'll put the details on the board in a minute. Justification is a complete defense. Mitigation is a partial defense. And so therefore, common law murder is defined as the actus reus with the mens rea without the defenses. This makes sense. Let's talk about the first of these, homicide. Now, a homicide is the killing of one person by another. So homicide is the killing of one person by another. And what this means is that the person who is being charged must be their conduct must be the actual cause, meaning in the but-for or substantial factor sense, and must be the proximate cause in the usual sense that the death of the person must not be too remote from the conduct of the person who is charged with it. Now, we have some interesting examples here. In the case of the mentally ill grocery store clerk, there is no question that Don killed Vic. His conduct, he pushed him, he fell, he hit his head, he died. So we have homicide element satisfied. Convenience store, Don shot Vince. There's no question that Don is the actual and proximate cause of Vince's death. Here, Don shot Vic in the head, and Vic went to the hospital, and the doctors pulled the plug. And Don is saying the doctors killed Vic. They pulled the plug. And there are two explanations for this. One is that when Vic arrived at the hospital, he was already brain dead. And in all jurisdictions now, brain dead is legally dead. There were some jurisdictions, I don't think they exist anymore, where the termination of respiration was dead. And this person's respiration was continued by artificial means. And so Don is saying, well, he was still alive, at least in some states. He was still alive, and therefore I didn't kill him. The doctors pulled the plug, and that's what killed him. And an answer to that, besides the brain dead, the answer to that is that after Don shot Vic in the head, other things which Don is looking for something that is going to terminate his liability. Well, to terminate his liability, you need something like an unforeseeable intervening event that changed the outcome. If, for example, you push someone and they fall, just an ordinary push and fall, and somebody else comes up and shoots them with a gun, well, that's not connected to you in any way. Well, that's an unforeseeable intervening event that changed the outcome. Here, after Don shot Vic, Vic went to the hospital and they put him on life support. And you're not going to leave people on life support when they're brain dead for the next 50 years. So it's quite foreseeable that at some point the plug's going to be pulled, and it did not change the expected outcome. After Don shot Vic in the head, you expect Vic to die. And so it was not an unforeseeable intervening event, and it didn't change the outcome. And so his explanation will not work. And it comes up under proximate cause, namely that Don is claiming that these intervening events of pulling the plug terminated his liability, and the answer is no, it did not. So homicide, this doesn't come up. In almost all cases on the bar exam, the bar examiners tell you that A killed B. And so you really don't have a homicide problem. This is one of the very few problems where you had to decide, did Don really kill Vic, since the doctors pulled the plug, and that's here. Secondly, malice. We have homicide with malice. Now, the malice can be satisfied in 4 ways. Number 1, intent to kill. Now, in the case of the mentally ill grocery store clerk, the clerk said, when they pushed the customer, said, I'll kill you. And, that could be taken as intent to kill. But when you say, I'll kill you, and all you do is push somebody, you don't, pull a gun and shoot them or hit them with a hatchet or something. All you did was push them. Then it's really more of a figure of speech, I think, rather than really showing the person's intent to kill. So the mentally ill grocery store clerk, when they pushed Vic and killed him, there was probably no intent to kill there. A second way, well, in the convenience store case, when Don shot Vince, obviously shooting Vince with a gun is intent to kill. And the way you get there is you can point out to the bar examiners that when a person uses deadly force, like a knife or like a gun or some weapon which causes death, if a person uses deadly force, then the jury is permitted to infer that the person intended to kill somebody. And so here, Don shot Vince, and so we have intent to kill. And Don shot Vic here in the assault case, and also we have intent to kill. A second way to satisfy malice is intent to inflict great bodily harm. Here in the mentally ill grocery store case, where Don pushed Vic and Vic fell, I doubt that you could find that Don intended to inflict great bodily harm just by pushing somebody. In the case of the convenience store, we already have intent to kill with a gun, intent to kill with a gun here. A third way to find malice is wanton conduct. Now, this wanton conduct has to be conduct that is just utterly in total disregard of a high likelihood of great bodily harm or death to somebody. For example, a person who shoots a gun into a moving passenger train. where there are likely to be people there. And the person is basically saying, I don't care if somebody gets killed or not. Firing a gun into an occupied house qualifies as that. There have been cases where people were driving drunk, and not just your ordinary drunk driving case. We're talking about the case where the person was way over the limit, 2 or 3 times, they're barely alive, and they're out there driving a car and hit and kill somebody. You can make a case that this person basically was saying, I don't care whether somebody gets killed, I'm going to drive this car home, and that's wanton conduct and utter disregard of a high likelihood of great bodily harm or death. Wanton conduct. Be careful here, because the defense that is sometimes offered is that, gee, I was so drunk that I was not consciously aware of the fact that I was engaged in this wanton conduct. And you have to be aware of the fact that what you're doing creates a high likelihood of great bodily harm or death. You have to be aware of the fact that what you're doing is causing that risk. If you're driving along the street and you drive over a stick of dynamite or something and it kills somebody and you had no idea this was happening, well, you did engage in conduct, but you were not consciously aware that this is likely to kill somebody. So a person who is very, very drunk might say, I was so drunk that I was not consciously aware that what I was doing, driving a car, is likely to kill somebody, or shooting a gun is likely to kill somebody, or whatever the person did when they were that drunk. And the answer is that the social policy is, if a person gets drunk and then they act, you treat them like a sober person. You don't get any social credits for being drunk. And so you treat this person who shot into a moving train or whatever they did, that were driving the car with a very, very high alcohol content, you treat them as though they were sober, and that's how you get the wanton conduct. And the fourth way to find malice is under the felony murder rule. The felony murder rule says that if you are engaged in one of the inherently dangerous common law felonies, inherently dangerous common law felonies, these are Barks, B-A-R-R-K-S, the inherently dangerous common law felonies: burglary, arson, robbery, rape, kidnap, sodomy. Burglary, arson, robbery, rape, kidnap, sodomy are the inherently dangerous common law felonies. And if you're engaged in one of these inherently dangerous common law felonies and someone is killed, okay, that is felony murder, and that provides the malice for common law murder. Now, the problem with the felony murder rule is that there are 4 versions of it. And you are expected to analyze, when you have a fact pattern, to do the analysis on each of these 4 versions. The first version is the common law. The common law version says if anybody is killed during and because of the felony that the person doing it because of Barks, that's malice. Provides the malice, and you've got the murder already, the killing already, so it becomes murder. This type of murder always turns out to be first-degree murder. We'll deal with degrees in just a few moments. But the important thing is that common law says if anyone is killed. So what happens here is that if you're engaged in a bank robbery, for example, and 2 people engaged in a bank robbery, and the bank teller pulls out a gun and shoots and kills one of the bank robbers, and the other one gets away, well, somebody was killed during and because of the bank robbery. And the robbery, R, is in one of these, is in the Barks. And so if someone is killed during and because of the bank robbery, there is, you've got felony murder. Well, felony murder has always been first-degree murder, and when first-degree murder was invented, we'll talk about that in just a few minutes, it was to distinguish between the people who were going to be executed for what they did, first degree, and the ones who are not going to be executed, second degree. Now, we've broken up first degree into first degree murder and first degree murder with special circumstances. And now for execution, you have to have both first-degree murder and special circumstances. But at the time that first-degree murder was created to distinguish it, to break up common law murder into these two categories, common law murder is homicide, malice, and this, and you broke everybody who committed common law murder was executed. So we separated these people into first degree and second degree, and only people who committed first degree murder were executed, second degree was not. And the felony murder always created first degree murder. And so in my hypo, you can see that the second bank robber who was shot by the teller, that the first bank robber now has committed felony murder. And so you go off and execute the first bank robber because of bank robbery number one, because the teller shot bank robber number two. And most jurisdictions say, no. That's not what the felony murder rule was about. That what we're trying to do is to stop the felons from killing innocent people. If some person kills one of the felons, we don't want to execute the other felons just because felon number one did it. And you turn to the extreme case, and you got 4 people robbing a bank, and the bank teller shoots one of them, and so now by these rules you would execute the other 3. And that just doesn't seem like reasonable social policy, and so we begin to change the rules. And the second, some states still technically follow that. The second version, you have to discuss this, that version I just described to you, the common law version of felony murder rule. The second version is called the red line view. And, this is a little hard to read, so I'll repeat it several times when I talk about it. The red line view. The red line view comes from a case called Red Line versus the Commonwealth of Pennsylvania. And in the red line view, the deal is that it's just like the common law felony murder rule, except it does not apply if one of the co-felons was killed by justifiable homicide. So if the police, for example, killed one of the co-felons by justifiable homicide, you would not apply the felony murder rule. The third view of the felony murder rule is the California. And the California view of the felony murder rule says that the felons themselves have to personally do the killing or be deeply involved in the killing in order to apply the felony murder rule. So that, for example, in the famous case of California versus Washington, someone else did the killing. Someone from a balcony shot one of the co-felons. So a better example, though, is a case where the police, for example, are chasing someone. Someone just robbed a bank, and they're trying to get away, and they're driving through the city streets, rushing, trying to get away. Now, obviously, this kind of behavior is wanton conduct, because if you drive fast through the city streets and run through enough traffic lights, sooner or later you're going to hit somebody. So this would be driving recklessly through the streets trying to get away would be wanton conduct. And if the felons hit and killed somebody in a car while doing that, you would find wanton conduct as a basis for providing the malice. When you do this, though, you'll end up with second-degree murder rather than first, as you'll see in a few minutes. On the other hand, instead of the felons hitting someone with their car, let's suppose the felons are trying to get away, and the police fire. Let's suppose the felons start a gun battle with the police, so they didn't shoot first. And then the police shot back, and in the course of shooting back, the police hit a pedestrian, or the police car chasing the crooks hit a pedestrian. So somebody else did the killing besides the felons. And the point is that the California rule says the felons themselves have to do the killing, and so you would not get felony murder rule in that case. You would get wanton conduct, and you'd end up with second-degree murder. And the fourth version of the felony murder rule is the model penal code. And under the model penal code, felony murder has simply been abolished. It's not considered a good idea. The idea is that if you intend to kill somebody and you want to kill them, or you act like you don't care whether they killed or not, that if you do that, yeah, that you can see the possibility of executing somebody then. But when someone's state of mind was to do something else and someone got killed, the Model Penal Code says no, you should not apply the felony murder rule. A lot of states do. Most states do. A few don't. Michigan follows the Model Penal Code and a few other states, but most states follow one of these. When you have a felony murder problem, you have to do all four of these. Now, in our examples, we have the mentally ill clerk who was not committing some felony. You could argue that maybe this was a felony assault or something, but the felony that is used to satisfy the felony murder rule has to be a felony that is independent of the way the person got killed. In other words, if a person is robbing a bank and kills somebody, the bank robbery is independent felony. But if you just shoot somebody and the person dies, you can't say that this was an assault with a deadly weapon, which is a felony, and the person died, and therefore we have felony murder. Attack somebody with a knife, this was assault with a deadly weapon, the person died, so we have felony murder. That doesn't work. The felony needs to be independent of the felony that is used to satisfy the felony murder, like the robbery or something, needs to be independent of just the way that the person got killed. So we do not have felony murder here because we don't have an independent felony in the mentally ill grocery store case. The convenience robbery, we do have a felony murder because clearly Don and Art were robbing the convenience store and Don shot and killed Vince. So that is clearly felony murder because someone was killed during and because of the robbery. During and because of the robbery. That during and because is very important. It has to occur during the commission of the felony, and it needs to be related to the felony in the sense of the person's trying to get away or trying to get the money or whatever it is. The during the commission of the felony is important because if the person in this convenience store, in the real problem, what happened is they had completed the convenience store and Don had killed Vince, and they got off to there was another person involved named Bart, and they got away and got to somebody's house, and then there was another conflict at the house and somebody got killed at the house. Well, that was not during the commission of the robbery. So it's got to be during the commission. There's one other famous case where the person was robbing someone, and they had committed a robbery, and after this was at nighttime, they committed the robbery. They went to an all-night and stolen a car and committed a robbery, and they went to an all-night food place, and they ate, and they got back in the car, and they got on the Pennsylvania Turnpike, and finally, the next morning, they were arrested on the Pennsylvania Turnpike, still driving the car that they had used in the original robbery. And the court said in that case that this was still during the commission of the robbery because they really had not gotten to a safe place. They were still driving the stolen car. So that's an extreme stretch, but it happened in that case. During the commission of the felony, by the way, does not require that is during the actual moment of perfection. There's another famous case where a person was robbing a store, and after they robbed the store, they ran outside the store and they were running down the boardwalk in front of a bunch of other stores to get away, and killed somebody in the course of that. And so they did not kill someone during the actual moment of perfection of the robbery, getting the money. And the court said in that case that this was not felony murder because they didn't kill him during the robbery. Well, those are both extreme cases. Generally speaking, you can either figure out that it was still during because the robbery or whatever the felony is continues until the persons have reached a place of temporary safety. And you'll have, whenever that's presented to you as a problem, you will have to argue about whether or not the felony was over or not. And your conclusion won't matter. The points will be in your recognizing that there's a dispute here, and then you argued both sides of the dispute. No felony murder here in the mentally ill case. Felony murder in the case of Don killing Vince. And here, in the case of of Don killing Vic because Vic had assaulted his wife 3 months ago, in that case, in the actual call to the analysis of the question, better yet, what had happened is the DA had charged Don with felony murder because he said Don had assaulted Vic with a deadly weapon, the gun, and that was a felony and therefore felony murder. Well, it doesn't work, and you were expected to recognize that. So getting back then to our analysis of common law murder is homicide with malice, without excuse, justification, or mitigation. We understand homicide is the killing of one person by another, which means that the conduct of the defendant must have been the actual and proximate cause of the death of the deceased person. Malice is the state of mind required for common law murder. 4 forms of malice: intent to kill, intent to inflict great bodily harm, wanton conduct, and the felony murder rule. Now, this brings us then to the next part of common law murder. It is defined as common law murder is homicide. We've done that part with malice. And now without excuse, justification, or mitigation. So we need to deal with all 3 of those. Now let's get some more board space. Excuse. There are only 2 excuses, and these 2 excuses are infancy and insanity. Infancy and insanity. The insanity, there are 4 forms of insanity that you are 4 views as to what constitutes legal insanity, and you're expected to know all 4 of them and to do the analysis of all 4 when the problem comes up. There's the McNaughton rule. There is the irresistible impulse. The Durham. And the model penal code. This is not the lecture where we want to go in depth on each of these, but we need to do enough so that you really understand what's going on. The McNaughton rule is a rule that says that a person is insane if they were, as a result of a mental disease or defect, they either did not know what they were doing or did not know it was wrong. Now those are very high standards. To be so crazy you don't even know what you're doing, or if you're doing it you have no idea there's anything wrong with it, that's very crazy. And those standards are extremely high and hard to meet. And so we find other views of what constitutes legal insanity. The irresistible impulse is the case where the person is unable to stop what they're doing. Now, this gets debated in a lot of situations because you look at the case of the kleptomaniac, the person who cannot stop stealing stuff from stores. And you can stop yourself, commit suicide. That'll stop you. And so what do you really mean by the person cannot stop? And there's a fuzzy boundary there as to what is meant by that, and you need to discuss that if this comes up. The Durham test simply says that what the person did is the product of a disease or defect, and the model penal code says combines these first 2, the McNaughton and the irresistible impulse, combines those and softens the boundaries. The model penal code says, as a result of a mental disease or defect, McNaughton says a person does not know what they're doing. And what the model penal code does is to soften that, and it's like the person does not fully appreciate what they're doing. They do not appreciate what they're doing, or cannot appreciate the wrongfulness of it. So they soften that so that you can meet the standards more easily. Now, in our case, if we go back to our case of the mentally ill grocery clerk who pushed the person who fell, hit his head, and died, that person says, "I'll kill you," so that you can't say that person didn't know what they were doing. They were pushing him. And irresistible impulse, could the person have stopped that? Well, we don't know. It was an impulse. McNaughton rule, person could not appreciate the quality of their act or its consequences, and we don't know. Product of a mental Durham, product of a mental disease or defect. Well, we don't know. And the actual problem, they gave you a little bit more detail about a mental disease or defect. You don't really know if this is a product of a mental disease or defect. So what it comes down to is that under McNaughton, I don't think the person is crazy, because I don't think this store clerk, either did not know what he was doing or didn't know it was wrong. Under the irresistible impulse, he might not have been able to control that. He's been in and out of mental institutions all of his life, and if part of the reason he was in these institutions is because of this impulse control or lack of it, then he may have irresistible impulse. That may be a form that of insanity that he can satisfy the requirements. The Durham rule, is this the product of a disease or defect? Well, first of all, I think there's only one state that follows the Durham anymore. And we don't know if this is the product of a mental disease or defect until we know more about his hospitalizations. And the facts didn't tell us very much more about that, so you explain that if his mental disease or defect, if his hospitalizations were because of this kind of impulse control, then maybe in fact he is unable to control, and this is the product of a mental disease or defect. And finally, the model penal code, the person either cannot appreciate what they're doing or they're unable to control it, but with the softer boundaries, you can perhaps make that standard that I think the person probably knew what he was doing when he pushed him, but maybe either didn't know it was wrong and could not, they lacked the ability, substantially lacked the ability to control it. In other words, the model penal code, instead of saying the person has irresistible impulse, they can't stop it, the model penal code says if the person lacks substantial capacity to control their conduct. And you can make an argument for lacking substantial capacity to control their conduct, and that's part of the model penal code rule. So we may have insanity under the model penal code. We do not have, there's no insanity involved in the other two examples, the convenience store robbery or Don killing Vic for assaulting his wife. So getting back to our problem, the excuses are infancy and insanity. McNaughton rule we know about. We cannot meet those standards. Irresistible impulse, maybe this clerk could meet that. The model penal code, a better chance because they soften instead of cannot control the conduct, they lack substantial capacity to control the conduct. And you might be able to meet that standard based on the person's mental history. Now, excuse, justification. The difference between excuse and justification is that in the case of excuse, we are saying this person did a bad thing, but there's really not much we can do about it. An infant picks up the family Uzi and kills a few people, not even knowing that that's what it does. There's really nothing you can do about it. An insane person who is truly insane picks up the family Uzi and shoots a few people and thinks that he's cooking dinner. Well, there's really nothing. You can put the person in a controlled environment. There's no punishment that's appropriate because the person didn't even have any idea of what they were doing. So in the case of excuse, we're saying, yeah, this person did a bad thing. There's really nothing we can do about it. In the case, but we don't want them to do it again. In the case of justification, where society is saying to the person, what you did was justified, and if you get these same situations again, do the same thing again. Okay? Somebody tries to kill you, you kill them first, and that's perfectly okay. So the justifications are, first of all, public authority, and the public authority, this is the executioner in Texas that's busy working overtime, and the others are the privileges. And the privileges are self-defense, defense of others, and prevention of crime. If a person is, the bar examiners want you to know more about self-defense than just how to spell it. They want you to know the details of self-defense. So if this comes up in a problem, you've got to talk details and so forth. Justifications, in our case, in our examples, there is no justification for what the mentally ill store clerk did. There is no justification for Don shooting Vince in the convenience store robbery. And if Don had killed Vic when he got into the house and caught Vic assaulting his wife, we'd have a different problem. But he tracked him down 3 months later, and so we don't have self-defense, prevention of crime, defense of others, and so none of these are justified. So there's no justification in either of the three examples. Excuse, justification, and finally mitigation. Now, let me point out that excuse and justification are complete defenses. You can make out either of these, the person walks out of the courtroom free. So excuse and justification are complete defenses. Mitigation is like a partial defense because it will reduce what would have been common law murder down to voluntary manslaughter. So it's a partial defense in that sense. The three ways to get this mitigation are, first of all, the imperfect privilege. Now, the imperfect privilege happens in the case where a person is at home late at night and someone is coming in the window goes up, and some party's coming in the window. 2 nights ago, somebody had just burned down a house down the street and killed all the people inside the house, and the whole neighborhood's upset. And this body is coming in the window at 3 o'clock in the morning, and the scared person gets their gun off the night table, where I'm sure everybody keeps their guns, and shoots and kills this intruder coming in the window. Well, the intruder turns out to be some family member who left their key, lost their key, and so the person thought they had the privilege of either self-defense or prevention of crime, and turns out they didn't because they just weren't careful enough. well, you're going to charge this person with murder when it was an honest mistake like that? Probably not. So this imperfect privilege would mitigate what otherwise would have been common law murder down to voluntary manslaughter. Please keep in mind that you don't get to voluntary manslaughter unless you have a situation that would have been common law murder and you have the mitigating factors. You have to have the malice, because voluntary manslaughter means just what it says, that the killing was voluntary. The person actually tried to kill him. You shoot a form coming in your window at 3 in the morning, you can't say I didn't intend to kill him. So you have voluntary manslaughter. You can get there by the imperfect privilege. The next way is by the heat of passion. In these heat of passion cases, you need to show that the person was adequately provoked and they did not have adequate cooling time. Now, each of those has two parts to it, the adequate provocation and the cooling time. The provocation has to meet two standards, objective and subjective. The provocation, objective, means that the provocation was such that a reasonable person would have acted out of blind passion in that situation, and that this person subjectively was so provoked that they did in fact act out of blind passion. You need both of those. And then the not adequate cooling time. Again, you have the objective and the subjective test. The objective test is saying that a reasonable person could not have cooled that fast. The subjective test is saying this person, in fact, did not cool off that fast. Now, if we look at our examples, in our examples, you see that the mentally ill clerk acted quickly, and can they meet heat of passion standards here? Well, the only thing that the customer in the store said to this clerk was something like, you ought to be in a controlled environment or something. So a reasonable person would not have been that provoked by that. Now this person, the crazy person, the mentally ill clerk, was in fact provoked that much, but a reasonable person would not have. So you wouldn't meet the provocation standards. Cooling time, it's clear that there was no cooling time because this all happened very quickly. So an objective person, a reasonable person could not have cooled that quickly, and this particular person did not cool that quickly. But still, the store clerk case will not meet the heat of passion standards because a reasonable person would not have been that provoked by those circumstances. In the convenience robbery and the Vic assaulting his wife, well, if Don had dealt with Vic while he caught Vic assaulting his wife, you might have a case for a mitigation to voluntary manslaughter. But in fact, what happened is that Don didn't find this person for 3 months. And when he finally found the person, he took a gun with him and went out and got into another heated argument. Well, when he got into the second heated argument with the person who had assaulted his wife 3 months earlier, he will make the argument that it is a result of that heated argument. It rekindled the anger that he had 3 months ago, and he shot him out of that anger. And that's his argument for voluntary manslaughter. Well, let's see. Could he meet the standards? Let's take a look. For the heat of passion defense, he's going to, was there adequate provocation? Well, objectively, a person might easily have, a reasonable person, when they get into a reheated argument about the assault 3 months ago, might have gotten that provoked. And this person claims he did get that provoked. We don't know if the jury's going to believe that or not. Next, the cooling time. Well, we don't know very much about that argument, and this is a defense, and Don's going to have to prove with the preponderance of the evidence that there was insufficient cooling time once the argument got underway, and that in fact he did the objective and subjective standards, that a reasonable person could not have cooled that fast after the argument got underway, and that he in fact did not cool. So we don't really know if our guy Don, who killed Vic for assaulting his wife, he can meet these heat of passion standards, but that's his argument. Third way to find mitigation, besides the imperfect privilege and the heat of passion, the third way to find the mitigation is through a diminished capacity. Diminished capacity is a very limited argument. Very few states have the rule, and when they do have the rule is that you have to show the person has to prove the burden. These are, by the way, all these defenses, the defenses are on the defendant. They have to prove that. The prosecution proves, the homicide and the malice, and the defendant's got to come up with these defenses. And the defense of diminished capacity requires that the defendant show that he did not have the mental capacity to form the intent that's required for the crime. In other words, a person is, they're not necessarily crazy, but whatever state of mind that this crime requires, that the person simply could not have formed that state of mind because their mind is so defective that there's no way they could have formed the state of mind that is necessary for the crime. Okay, and that's the diminished capacity. Very few states follow it, and there is none of our problems do we have an example of that. So this is how you establish common law murder. You establish it by showing that there was a homicide with malice. Don't forget the kinds of malice. There are 4 ways to establish the malice. Homicide with malice without excuse, infancy or insanity, justification, public authority or other privileges, or mitigation. Excuse and justification are complete defenses. Mitigation will reduce the crime down to voluntary manslaughter. So we understand common law murder. What we next need to do, now that we understand how common law murder, is to look at the next step is the way common law murder got divided into first degree and second degree. And then first degree murder got divided again into first degree without special circumstances and first degree with special circumstances. So we will take a break now and pick it up at that point.